attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is a continuation in a LawCast series talking about the SEC's proposed rules to modernize and simplify disclosure requirements for public companies, investment advisors, and investment companies. In this LawCast series, I have been going through the rule amendments recently proposed by the SEC on October 11, 2017, following which I will go through the rule amendments proposed earlier on July 13, 2016, which amendments are slated for action this year. Compliance with Section 16A, Item 405. Section 16A of the Exchange Act requires officers, directors, and specified types of security holders to report their beneficial ownership of a company's equity securities using forms prescribed by the SEC, such as an initial Form 3, amendments on Form 4, and an annual Form 5. Item 405 requires the company to disclose each person who has failed to timely file a Section 16 report during the most recent fiscal year or prior years. Section 16 reporting persons are required to deliver a copy of their reports to the company, though in practice, this is rarely done. The proposed amendments would remove this requirement and allow the company to review EDGAR filings for compliance with Section 16A. In addition, the proposed amendments would eliminate the need to include the heading at all if there are no delinquencies to report. Rather than include the heading with a statement such as none, they would remove the heading whatsoever. The proposed amendments will also remove the checkbox on the cover page of Form 10-K related to the disclosure. The proposed amendments include several changes to make the instructions and title of this section conform to the SEC's plain English requirements. Corporate governance, Item 407. The proposed amendments will update the instructions and information required under Item 407 to remove reference to an obsolete audit standard and rather just refer broadly to applicable PCAOB and SEC requirements. EGCs and smaller reporting companies are both exempted from Item 407 requirements, and the proposed amendment clarifies the instruction language accordingly. Outside front cover page of a prospectus, Item 501B. The proposed amendments are designed to streamline the front cover page of a prospectus and give a company flexibility in designing the page to tailor to their business and particular offering. The proposed changes include eliminating instructions relating to changing or clarifying a name that may be confused with a well-known company, allowing for a statement that the offering price will be determined by a particular method or formula that is more fully explained in the prospectus with a cross-reference to that page number, requiring the disclosure of the principal trading market and company symbol even if such trading market is not on a national exchange, such as if it is on the OTC markets, and streamlining the subject to completion legend that is usually included. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.